Hi, this is Doug Jones. Welcome to Help Me Help Mama livecast. Thanks for joining in today. It's just Doug, no Cindy today. So we're going to talk about a planning issue that people come into our office from time to time, and I know this is applicable to everyone watching here. So I want to talk about just a few things to plan for. People come into our office and talk about they want to get their ducks in a row. And if you are at journey stop 1 with your parent or your spouse and they still have capacity and they haven't gotten their ducks in a row, this is for you. It's time to do something if they can still do it. If you are one of the kids and you hadn't gotten your ducks in a row, well, same for you. So when people say they want to get the ducks in a row, usually what they're talking about is they've seen some bad stuff happen to other folks that they know, and they don't want that same bad stuff to happen to them. So what are we talking about? Usually it's three things, what I call the big three. First thing is probate. If you die and you've got assets titled in your name and there's no beneficiary designation on it, maybe it's just a bank account, maybe it's an IRA, maybe it's an insurance policy, maybe it's a piece of land or a house, and it's just in your name and you die, a lot of times that goes through probate. And probate process is different in every state. Some states it's very easy, some states it's not easy at all. But probate, and it can normally be avoided with a little bit of proper prior planning. So check with your elder law or state planning attorney, and you should be able to avoid the first of the big three. And obviously if you're family caregiver for mom or dad, it goes without saying, but we'll say it anyway, they've got to have capacity, mental capacity, to sign all of these documents, legal documents. They got to know who they are, what they're doing, what assets they've got, who they want to leave it to. But again, talk to your attorney, have them talk to their attorney to see if they can do it. And if they've got documents and they haven't been reviewed in a long time, for sure get them reviewed. Okay, so first the big three, probate. Second of the big three, losing it to the nursing home. And this is not the right way to say it, and I know it probably makes some nursing home people mad to hear that, but if you work for a nursing home, you've heard it yourself 1,000 times when people come into your nursing home. Well, they say, I don't want you guys to get everything. I want to protect it from the nursing home. Well, and again, as you know, this is not even accurate. The nursing home doesn't take your stuff. They don't want your stuff. They just want to be paid. And if you go to the hospital first and have a qualifying 3-night stay, go to the nursing home, Medicare pays for up to 100 days, and then after that, Medicaid would kick in after your private paid for a while. The trouble is, people private pay for way too often and wind up losing a lot of it when they didn't have to do so. So that's a second of the big three that can be avoided with proper prior planning. And the third of the big three, and this is a biggie because no one thinks about becoming incapacitated before they die. They think about dying. They think, well, when I die, I need a will or trust or something to leave my stuff to who I've left behind. But, you know, a big chunk of us become incapacitated before we die. Stroke, Alzheimer's, whatever, and we can't act on our behalf, and we need someone to act for us. I can't tell you the number of times I've sat down with, usually it's women, because us guys usually, you know, something happens first, and she said, well, my husband had a stroke, but we've been married 50-something years, and I know what he wants. And well, you may know, you probably do know, but you're not him. Unless you've got something in writing, you may not be able to act on his behalf. And if you're one of the adult kids, and it's mom or dad we're talking about, you sure don't have the authority to act on their behalf. Now, you may be named on their account, and maybe you can use the assets of that account, but before you can sell assets or get access to their money to use for their care, in most instances you need properly prepared power of attorney. Again, check with your attorney to see how it is in your state. So power of attorney, and if you don't have that, a lot of times a guardianship is required. The same thing can be said for healthcare documents, healthcare power of attorney, and all of your necessary healthcare documents. So that's the big three. This is a short message today, but I wanted to pass it on to you. 3 bad things that can happen, and if you're pre-planning, which just means you may not have done it yet, or it's been a long time since you've done it, you need to get it reviewed, but you're worried about those 3 big bad things you want to avoid. And the good news is, if you still got capacity, you can normally do something to avoid those. So get with your elder law attorney or your estate planning attorney and check that out and do something while you still have the opportunity to do it. That's all I have today. Thanks for joining. Please put a comment down below. Share this with someone, and we will see you again tomorrow on Help Me Help Mama Livecast. Have a great day.